Shoot, should have done that earlier.
Good morning, everybody. Welcome to MedWell Unscripted Live. We are so excited. Today we're talking about a very hot topic that everybody wants to know the answers to. We're talking about medical marijuana and the law, what you need to know. And we have a special guest with us today. We have Chief of Police John F. Carmichael from the Walpole Police Department. Welcome, everybody. How is everybody today?
We're doing great.
Good. Awesome. Thank you for having me.
Awesome. So we have Emily Waxman, our Director of Community Outreach, with us today. And John is coming in from Walpole, and we're really excited. So we're going to start with just a little bit of housekeeping. We have our awesome Kayla from MedWell in the chat, always rocking the chat with information and helping answer any questions that you have. This is being recorded. So if you are catching the replay, no problem. Please leave a comment and we will absolutely get back to you. And so let's get started. Emily, share a little bit about with what you do with our audience.
Absolutely. So I am the Director of Community Outreach. I go out into all over the area to talk about how wonderful MedWell is, why someone would want to come to us to obtain their medical marijuana card. I get to talk about our amazing nurse practitioner and doctors. I also get to tell everyone the process, about how easy we make it, and let them know that we are able to see folks not only in our 7 locations, but we now offer amazing telemedicine visits 6 days a week. So I just like to be able to be a wealth of information for our patients out there or potential patients, and just be able to, again, let everyone know that MedWell is just the place to come to. So
awesome. So it was funny when we were talking before. So before we come on air, we're in this green room and we were talking with John kind of where he's from and all of that. And we you know, in Massachusetts, I think we're all kind of 6 degrees of separation connected in some way, right? Yep. So, John, let's share with us a little bit about your role in Walpole, and then I'd love to hear a little bit more about your story and kind of how you've been such a huge advocate for medical marijuana and kind of the industry, and you've really helped change a lot of things.
Sure. Thank you for having me. This is a great platform. It's very exciting to be here, and I appreciate it. I'm glad I could talk with everybody today. So I've been the police chief for about 5 years here in Walpole, and my history with dealing with this industry goes back to when I went to Curry College and I was getting my master's degree. And one of the things that I was very interested in was, you know, what we were seeing as far as decriminalization that was occurring across the country, medical marijuana and complete adult use legalization. And I got very interested in it. And so I did my thesis on marijuana decriminalization. And that was right around the time back in 2008 when, and before, when Massachusetts was considering decriminalization. And then, as we know, later on in 2012, medical marijuana came along in 2016 when we went with adult use. So one of the things I was very interested in was that if we were going to decriminalize, or we were going to have medical marijuana or adult use in marijuana in Massachusetts, that I wanted to kind of have my part as in keeping it safe. You know, I looked at it from a public safety perspective. And so my thesis ended up kind of rolling into having some knowledge to bring to the listening sessions back when we were doing decriminalization. And then as medical marijuana came along, into doing the listening sessions and then the DPH regulations. And so I had a lot of input, and it was very exciting to have input in making sure that as dispensaries started to open and medical marijuana rolled out, that we kept it safe for the person who's has their medical marijuana card, for the dispensaries, for people going in and out of them, for the neighborhoods. And so it was very exciting to be able to do that. And then that kind of turned into me being selected to be on that original registered marijuana dispensary selection committee. You guys remember that?
Yeah.
The first 20 RMDs that opened here in Massachusetts. So I was part of that small group of people that looked at all those applications.
Wow.
And it was very tedious. It was a lot of work, I'll be honest with you. But at the end, we thought that we really had the best 20 registered marijuana dispensaries for medical marijuana in Massachusetts that we all kind of had consensus on, and we're very successful. So those businesses continue today, and that is obviously, as you know, has grown tremendously over the years. So then I went from that to being selected to be one of the law enforcement representatives on the Cannabis Advisory Board. I'm actually the governor's selection as far as the public safety side of things. I'm on the subcommittee for public safety, and so we basically took a lot of the regulations and everything from adult medical marijuana and applied that to adult use.
Adult use, yeah.
And, now, as you know, the medical marijuana program was originally at a DPH, and now they've transitioned that into the Cannabis Control Commission. So it all kind of follows under that umbrella now.
Right.
And then that leads me right to here. So here we are.
Well, we're glad you're here. There's so many. I'm sure that a lot of the questions we're going to talk about today are questions you get asked every day. So let's get into it. So let's first talk about what's the amount of cannabis you can carry if you have a medical card.
So if you have a medical card, you can carry your 60-day supply. So what happens is once you get your certification through the website and you're given your card, that card, you're given a temporary card first, and that card is usually good for about 14 days. And that's why they process everything and send you out your final card from now the Cannabis Control Commission. So usually a 60-day supply in Massachusetts is 10 ounces. But it all really depends on what the doctor's certification is. So when the certification, it may be for 2.5 ounces. It may be for 5. The vast majority of them, I think, are 10 ounces. So a medical marijuana patient carrying their card with them can carry up to that 60-day supply, which is usually the 10 ounces. And one of the things that's in the law and the regulations is that if for some reason you're stopped by law enforcement, that you present your card, and that card can be verified through the criminal justice information system. And so the officers can actually run the card through a very secure system and check as to the validity of the card and then the amounts that are allowed. So that's pretty much the way that it happens.
Great. And I just want to add to that, because I know we have viewers from, we have somebody from Rhode Island. So that is Massachusetts only in terms of regulation and if you have it on you. So I just want to make sure that everybody understands that. And thank you, because that was my next lead into the question of what happens if you get pulled over. So another question that comes up a lot is, can you get high and smoke in public if you have a medical marijuana card?
So medical marijuana and the adult use laws are different. So in the adult use law, 94G, that basically says that all of the things that are covered under medical marijuana law don't apply to each other, right? So that they're separate laws. So the answer to that question is it depends. Now, adult use marijuana has a public use provision in there, so that you can't use it, in public. You can't use it on the sidewalk or anything like that. Medical marijuana is a little bit different, and the only time that public use is prohibited with medical marijuana is if that city or town has an ordinance or a bylaw that addresses public use. Okay, so and you'd have to, if you live in a community, you would have to actually check with that community to see if that town or that city has an ordinance that prohibits public use. Now, as you know, a school in certain areas, government institutions and that kind of thing, there also can't be public use. But unless there's an ordinance or bylaw that forbids it, it doesn't apply to medical marijuana. And again, it's always important to make sure that you have your registration card with you in the event that you were stopped or anything like that.
Awesome. So I guess one of the other pieces to that is, so you can smoke in your home, on your lawn. What if you're in an apartment building or government housing? Is that, again, they would have to check with the laws or the mandates within that unit?
Mm-hmm. So these are very good questions. So again, adult use and medical marijuana have different provisions for this, right? And believe it or not, we do get calls quite frequently, like say in an apartment building that, you know, they can smell the odor or, you know, the smoke in the hallway and that kind of stuff. So we do get those calls. With medical marijuana, there's nothing in the law that prohibits a landlord or the people who own the property from banning it, you know, in the apartment. So in other words, they could put that on the lease. Many places don't do that, but what they can't do is prohibit somebody from other forms of using it. So, you know, edibles or concentrates and that kind of thing. Right. The other thing is with medical marijuana, they can't, it only comes down to that if you're posing a health risk to somebody else. All right. So the difference between posing a health risk to somebody else or a potential health risk to someone else versus under adult use, where again, they can put it in the lease that people could not use it. Again, you can't, that doesn't include edibles and concentrates and that kind of thing. So the unless the person is actually like causing harm to somebody else, the police really aren't going to address it. There are situations when it could turn into like a disturbing the peace type of thing. Okay, so like other people are annoyed or bothered by it, and you know, so we've had very good luck with when these situations happen, just going there and just kind of maintaining the peace and talking to each side and you know, reaching a solution to it. So that's most of the time the way that that's handled. The other issue is federal or subsidized housing, you know, Section 8 type housing. Those areas can completely forbid it and prohibit it because they are, it's the, you know, under federal law, it's still illegal. So they can still apply that to federal housing.
Right, right. We've definitely had some patients that have dealt with that. So I was so happy to be able to have you on to explain that, John, because I think that can get a little sticky at times.
Yeah. Yeah.
Kind of in lines with that topic of kind of under, you know, the influence, how does that work if you pull somebody over and there's question, you know, you have DUIs and all of these things, how do you deal with that? I mean, I guess, you know, so if somebody has a medical marijuana card, there's times where, especially kind of in the beginning phases, people are testing different products for their pain. Maybe they're too high and they get pulled over. How do you address that?
Yeah. Well, you have to be very careful with that, right? Because the police on the street, you know, we have to remember that they're obligated to remove people from the roadways that they believe are impaired, right? You can't stop somebody that, you know, that they believe to be impaired and let them drive away, because then something obviously tragic could happen. So in Massachusetts, anytime that somebody consumes a substance, whether it be alcohol, whether it be prescription medication or even medical marijuana, if that drug causes a diminished capacity for that person to drive and operate the motor vehicle safely, then that really kind of meets the threshold of driving impaired or driving under the influence. And so it's really important for people to kind of understand and learn their threshold, like you say, like in the beginning, like really, we always said in the meetings and everything, ease your way into it, have a good kind of understanding of where you are, especially with edibles and those types of things that might, you know, take effect a little bit longer than, you know, in smoke forms and that kind of thing. So it's very important. You know, the THC, the components that are in the, you know, in marijuana can impair your judgment and your reaction time and, you know, even your cognitive thinking. So it's important that you know where you stand as far as that's concerned. As far as, you know, the officers, you know, there's a lot of debate, and I'm actually on the Special Commission for Operating Under the Influence here in Massachusetts, which was that 13-member panel that made all the recommendations to the legislature on how we should address the operating under the influence laws. And believe it or not, like, it was a very diverse group of people with all different disciplines. We had defense attorneys, we had the ACLU, we had the police, we had toxicologists, doctors, judges. It was a very good group of people. we reached a consensus to try and address some of the shortfalls of operating under the influence, and failed miserably. It didn't. It ended up kind of just dying in committee and didn't get very far. But at the end of the day, if the police officer stops somebody and they, it might be just the odor, it might be somebody's speech, it might be their eyes, glassy bloodshot eyes. They're going to be making those physical observations, and they're obligated to, investigate further. So they may ask for an exit order, and in Massachusetts, they may even, subject the person to field sobriety testing. Now, there's a lot of debate on how effective field sobriety testing is here in Massachusetts, because really they were designed for alcohol and not so much for drugs. So it makes it difficult, but they have to do their best job to address it. And so there's a case that came out called Commonwealth versus Gerhardt, and that case there was an OUI case addressing with marijuana, and they found that officers can't testify that the marijuana caused the impairment. They have to be able to more just kind of explain the behavior, their attitude, the demeanor, what was the person's attentiveness. And that is what they would use as a threshold to determine if somebody has that diminished capacity, that impaired ability to drive. And we do, in Massachusetts, we have drug recognition experts, and they are also not allowed to testify because there's a lot of debate as to the science of that as well. And so the commission even tried to do implied consent, which is like a breathalyzer, right? When you get back to a police station with alcohol, they're offered a breath test, and the same was going to apply to a drug recognition expert. And so that still hasn't made it there yet either. So and I'm not just saying, it's not just with cannabis, it's also with prescription drugs and with cocaine and with it's really with any substance. It's kind of the same thing as applying to this. So at the end of the day, it comes down to a judgment call by the officer. And I'll be honest with you, the majority of time that somebody is suspected to be, using cannabis and driving, the vast majority of the time they're probably going to be allowed to continue on their way, because the officer most likely will feel that they're okay to drive,
Okay.
And I posted this, and this is kind of led into this conversation. This question was, Donna was using the example. She takes capsules for her breast cancer treatment, and it's definitely difficult sometimes to know how long, because I know edibles and like vapes are very different in how they enter the system and how long it takes for actually to feel the effects. So sometimes, like you had mentioned, and I know one of the things that our MedWell doctors talk about, and then even patient care people within the dispensaries, is take it slow, and take as minimal amount to get started, and then over time increase it as you find that you're more comfortable with it.
And I think the best thing too is anytime it's with an edible, you really want to be home. You really don't want to take it and then go and run some errands and be on the road behind the wheel, because you really don't know when it's going to start hitting you. And to put yourself in that position, I would think becomes then a little frightening. So it's just good good practice to be home. I'm sure you would agree, John.
Yes, absolutely. It is really, because everybody's going to be different. And you really know how you feel afterwards, and even whatever products you take and how long that's going to take effect.
Right.
So you really do just have to take that into consideration, and even if it's somebody acute use versus chronic use, somebody that's been using it over a period of time, a medical marijuana patient that has a certain amount that they use every day. It's the same with other medications.
Exactly.
If you take, Percocet for something, and you need to know that when you take that, it could cause some drowsiness and that kind of thing, and you have to take that into consideration before getting behind the wheel.
Absolutely.
So this is a frequently asked question and a big question. So So a person holding a medical marijuana card and also having a license to carry. Can you talk a little bit about if they can have both, how that, I know one of the things that we actually, because you're here and you're an expert on the subject matter and part of this is a question that, to be honest with you, we have avoided having in our lives because we know this is a very controversial question. So can you share with us kind of how that works and how, really everything around it? That would be great.
That is a very good question. That's actually one of the ones that I get a lot too. And even, a lot of times when I get that question, it's in the form of an application for a license to carry. And people, and you have an interview with the person and they bring it up. So in Massachusetts, the first thing to remember is the medical marijuana law in Massachusetts requires that if the person qualifies as a patient, that there is no civil or criminal penalty, and that they don't lose any right or privilege, going forward for whatever that may be for those actions. So
right.
In Massachusetts, speaking specifically, the Executive Office of Public Safety and Security has addressed this with that we will continue to issue those license to carries. So in Massachusetts, there's 2 times when you can be denied. The first time is you can be disqualified because of a criminal history, right? Or mental history or that type of thing where it's documented. And it's a statutory disqualifier. And that statutory disqualifier is anytime there's a conviction of a crime that would have carried more than 2 years in the house of correction or in prison. So that's the there's a disqualification for the statutorily. The other one is for if the licensing authority felt that it was a suitability issue for whatever reason, then it has to be articulated, and it can't be arbitrary or capricious or anything like that. Where a medical marijuana card, when we do the background check, we do a board of probation check, we do a III, which is across the country type of check. They don't check the person's status as a medical marijuana patient. It's not part of the background check. And when I actually put it down, when you apply for your license to carry, one of the questions is, have you ever been convicted of the unlawful use, possession, or sale of controlled substances as defined under 94C, Section 1? And so that other issue, that 2 years I was talking about, possession of marijuana in the past was a misdemeanor. It was up to 2 years in prison. And then the second offense was over 2.5 years. So even though that occurred it could be a statutory disqualifier, we don't apply that anymore. So if you have a possession conviction in Massachusetts, that license will still be issued. All right. And the same holds true for if the person has an active medical marijuana card. Now, that doesn't mean that you can carry while under the influence, right? So in Massachusetts, if you were given a license to carry, you also, again, just like driving, you have to be careful that you're not possessing a firearm while you're under the influence. And again, that same standard as like an OUI might have to be met. So, and that again, that includes alcohol, that includes any other type of drug. And so that could be a reason to disqualify somebody or suspend their license, and that kind of thing. So the short answer is yes. If you do have a medical marijuana card, you can still get a license to carry. And if you do have a possession conviction in the past, you can still get a license to carry. There could be issues with distribution or distribution of Class C, THC. So if there's a distribution issue, that could still be a statutory disqualifier.
Thank you so much. I'm actually going to take this
I'm
clip.
so happy you cleared that up, because it is asked on a regular basis to myself and all of the staff at MedWell, and that there's such a fine line with it, because federally it's still an illegal thing, so it becomes a very hairy thing to answer, and we certainly don't want to ever say something that would make it so that it would put them in jeopardy of having that license to carry card.
Right.
But I'm so thankful that you answered that, because I think people think that, when they get a medical card, that opens them up to all this information that goes out there that, the government and the police and all these, folks can take a look at, when in actuality, it's a very private thing that goes on when you get your medical card. And, it doesn't mean that that's going to open you up to being scrutinized when it comes to that license to carry. So,
right.
I'm so thankful that you
and
were
what you
able to
just said, the privacy issue is exactly right. So when the local police chief files a license to carry, and we do the background check and we run everything through the system, we don't share that with the federal government. The federal government actually doesn't even have access to see just the medical marijuana program that local police like me do. So
Right.
there's not that interconnection. Now, when you talk about the privacy issue, that kind of addresses that, but there is still issues on the federal side. If you were to get a federal firearms license or be a licensed under the federal government somehow, they do ask questions about, marijuana use and that kind of stuff, where that would cause a problem. But for state purposes, for your license to carry here in Massachusetts, you can apply and you would be able to get your license to carry. There wouldn't be a statutory or suitability issue there. It is important, though, that on that question on the application, when they do say, have you ever been convicted of unlawful use, possession, whatever, if you do have that on your background, then answer yes, because I know a lot of people are going to see that question. They're going to be like, oh boy, like I'll try and just say no and answer that question wrong. It's going to come up. They're going to see it.
Right.
So just be honest with the question. If there was a past conviction and, like I said, for possession and that kind of thing, in Massachusetts, we do not deny it based on that.
So can I just ask a quick question? So is there a state level and then there's a federal level with obtaining your license to carry, only just because I have no idea myself? So
yeah, so there are times when people get a federal firearms license, and that usually it may be for selling firearms or being a dealer.
Okay.
So in that case, that's a kind of a different story there, but for state purposes, for an FID card, a license to carry, would be able to do that. Yeah.
Thank you so much.
So we have a question from our YouTube channel from Rob. Would that same protection also protect a person's professional licenses or CDL driver's license?
Oh gosh, that's a good question. So again, in Massachusetts, when we're talking about medical marijuana, the law is very clear that you cannot be penalized under Massachusetts law for any manner, denied any right, denied any privilege for the actions of having a medical marijuana card. Now, if just for purposes of getting that, I'm not really, I be honest with you, I'm not really 100% sure on this one, but again, you can't be denied any right of privilege in that licensing. And I would say that as long as, you're not stopped and it's an OUI issue or, that type of thing, that you would be okay.
Awesome. So just because it kind of made me think when you talk CDL in terms of, and I don't even know that you might be able to answer this, but employment. So is there, in Massachusetts, if somebody has a medical marijuana card, can an employer, how does that work with employment? Do you have to share that on an application? Can they get penalized for employment?
We get a lot of patients that worry about that. And, you certainly don't want to ever jeopardize anyone's ability to make a living for themselves. So that's a great question. So
at some point, there will be some huge lawsuit where there will be a decision that's made on that, if they haven't already.
Right.
But again, whenever you're filling out an application, you should be honest on your application, because you could, if they find out otherwise, that could cause a problem.
Of course.
For medical marijuana purposes and getting that card, which is a confidential, private thing in your life, somebody should not be able to deny you any right of privilege because of just that solely. And so I think you would have an issue if you applied for a job and you were denied because you had a medical marijuana card.
Well, I'm thinking drug testing, right? Because I know sometimes they do drug testing. So
Yeah.
at that point, you would absolutely want to tell them,
And believe it or not, we get this a lot of times with police officers and law enforcement, because obviously when we hire police officers, we do very robust background checks on them. And even though medical use, adult use is allowed in Massachusetts, police officers are still forbidden from using it or even getting a card, because we carry firearms, and there's a whole issue of we can't violate state or federal law, so thereby we would be doing that. So police officers in Massachusetts actually are completely out of that picture. So there could be some jobs where that same type of standard may apply.
Right. Sure. All right. So thank you for that. And especially on the kind of the permit to carry, I actually think I'm going to clip part of that piece of the video so we can have it on our website, because that question comes up so much. So thank you. All of these questions do, but that in particular has been one of the more challenging ones to answer. So thank you. Let's talk a little bit about being able to grow at home. How many plants can individuals grow, and do you need a medical card to be able to grow at home?
Yes, that's a really good question. So with a medical marijuana card, you can grow in your home, and it has to be your home. It has to be your permanent residence. You can grow what is necessary to accumulate your 60-day supply, whatever that may be. Again, that could be 2.5 ounces. It's usually 10 ounces. Right. So you can grow enough plants that over the period of that 60-day process, where you could grow enough to satisfy your registration. And now we have adult use, right? So this changed a little bit, because now we have adult use where it allows an individual to grow 6 plants in their home, and they can grow up. If there's 2 people in the house, they can grow up to 12. The other issue with that is also that if you're an individual and you grow 12, the worst fine, that's $100 fine. So it's not arrestable or anything like that. So what I kind of tell people is DPH never did it. The Cannabis Control Commission so far hasn't done it. They haven't established a number of plants. So it's going to be a situation where, if there was an issue with law enforcement, you'd have to just establish that, the amount of plants is going to be equal to what you would need to grow that 60-day supply. Now, is that 12 plants? It might be. Is there case law out there? Yes. We've had a couple of cases, I think, that have made it up to the SJC, where the police weren't able to show that person, the medical marijuana card holder, expected or intended to grow more than 10 ounces. And that might be based on experience. It might be based on, how many plants you might lose, a lot of different things. So it's, I hate to not give you an exact answer, because there isn't an exact answer. There's only what you would need to grow that 60-day supply.
No,
I think we could mention too, John, that, that's like in your own home. I would imagine that, being in, again, going back to the apartment complex or any sort of government subsidized place, it would almost go back to the same rules that we mentioned about the smoking piece of it too, correct?
Yes. The same with, they could forbid it on a lease or something like that.
Right.
And then also, as far as cultivation, you could also have a caregiver, and the caregiver could grow those plants in their own home. And the hardship cultivation, there's still no hardship cultivation license yet. That was, remember early on when there weren't very many dispensaries, there was going to be these hardship cultivation registrations where you would be able to grow your own cultivate at that point, because adult use wasn't in play then. Right. And so even though there wasn't that cultivation registration, just your registration card would actually count as being your cultivation registration.
Okay. All right, great. And so because you can grow in your own home, and you clearly, when you have a card, you can purchase and also rec. can people distribute it to others? Can they share their products? How does that work? I know on the rec side, it's probably a little bit more difficult than on the medical side, but how does that work?
So we can't do that. That's one thing that's still in medical marijuana and adult use, is that you can't sell it, you can't deliver it, you can't distribute it.
Right.
And under adult use, there's that provision there where you can give it away, and the certain criteria that has to be met when you give it away. Even with medical, even a caregiver, they can cultivate it and grow it and process it and deliver it and do all that.
Right.
But they can't do it actually for remuneration. So they can get what their actual expenses are and any expenses that are associated with it. But the law doesn't specifically allow you to cultivate it and give it away or sell it or do any of that. And that includes adult use as well. Like you can give it up to an ounce away, but you cannot distribute it for money. And it's interesting because I kind of follow when we go back to 2008 and we decriminalized and we looked at arrest rates, right? Arrest rates a couple of years before decriminalization, arrest rates a couple of years after, and what happened and how quick it happened. And then the same thing with medical and adult use, how those things turned. If you look at the NIBRS data, National Incident-Based Reporting System, which all police departments, or almost all in Massachusetts, submit to, their statistics to the FBI. There were more in 2019. There were many more arrests for distribution than there was for possession, which is very interesting.
That is interesting.
You can't be arrested until you outside of the home until you had over the 2 ounces amount. You can have an ounce. That second ounce is civil. That's a civil offense. Anything over 2 ounces would still be a criminal offense. And there was only about maybe 150 arrests in Massachusetts in 2019. Now that doesn't include Boston and state police, but that's extremely low number. And but the distribution charges or arrests were upwards close to 500 for the whole state. Again, not including Boston and state police, but so there's been more of an issue over the last year of distribution as opposed to possession. So that's an important thing to note, right? Like just unless you have a license from the Cannabis Control Commission or you're a registered RMD or something like that, legally you can't deliver or sell it.
And what's the penalty for something like that?
For selling Class D, so there's Class D, which is plant flower material, right? And Class C, which is concentrates or oils and that kind of thing. So there's a difference for distribution of Class D flowered material. It's a 2-year misdemeanor. If you were convicted of it, if somebody was convicted of it. And for a second offense, it would move that up to 2.5 years. That's where your license to carry issue comes in too, because once you're convicted of something, and it's not just marijuana, it's any crime that has more than a 2-year penalty, you could lose that license to carry at that point. So that's where that could come back. And Class C, as in like THC and that kind of thing, that could have a 2.5-year sentence. So even just that one time, somebody could run into a problem with an LTC.
Wow.
Yeah.
Well, John, this has been really amazing and eye-opening. I have dropped the link into the Cannabis Control Commission. And, I actually, as we're kind of wrapping up, I would love to, I know Emily and I would love to have a few of you on and have a deeper conversation in the future. So hopefully you're open to that.
Sure. I mean, the people on the Cannabis Advisory Board, which does make all the recommendations to the Cannabis Control Commission, absolutely amazing group of people.
We've had Nicole, who's absolutely wonderful. So yes.
Nicole and Mike and all of them. They're a great group of people, very passionate, and anytime I could help out, I'd love to do that. Sure.
That's great. And, one of the biggest things for us here at MedWell is really keeping our patients informed and educating them on the ins and outs that going on in the cannabis world. So thank you so much.
It's probably important to note, like, if people ever have questions, I mean, you can always ask me, but on the Cannabis Control website, there are links there for the medical marijuana program. All of the information on how to sign up and do that, whether you're a caregiver, dispensary agent, or patient. And so all that information is right on there. There's a lot of really good guidance documents on there as well.
Yeah, a lot of actually what we spoke about today is answered right on those links.
Right.
So that's a perfect place to go and check out if you wanted to learn a little bit more or just read up on what we spoke about today.
Yeah.
Awesome. Well, thank you so much for your time.
Yeah.
Thank you,
John,
Emily.
thank you.
John, we really appreciate it. Friends, definitely go over to the Cannabis Control Commission. Check out their website for information. And if you have questions about your medical marijuana certifications, please stop by medwellhealth.net. We also have a blog filled with great information, and our team is always available to answer any of your questions. Again, friends, if you're catching the replay, feel free to leave a comment and we'll be sure to answer those. And thank you, everybody. It's been a great conversation. This was awesome. And have a wonderful day, everybody.